Ladies and gentlemen, good evening and welcome to Politics in the Pub. My name is Howard Bell. I'm going to be chairing the session this evening. The topic is one which is very dear to every activist's heart, every social justice practitioner's heart, every lawyer's heart, probably the heart of everybody. Do we need, should we have, should there be a Human Rights Act in Australia? Regardless of whether you call it a statutory Bill of Rights, a constitutional Bill of Rights, a Charter of Justice, whatever you want to call it. Do we need one? It's a raging debate. It's up there with the environmental debate. We're blessed tonight, though, to have two experts to help us understand the ins and outs of the case for a Human Rights Act in Australia. Louise Goodchild is a legal expert and barrister practising at the New South Wales Bar. She practices across a broad range of legal areas and also specialises in human rights law, as well as equal opportunity, administrative law, children's care and protection and family law. Very wide-ranging practice. Louise is well known for her analytical and research skills and for having successfully challenged the status quo in a significant number of cases over a long period of time. Louise is also currently a judicial member of the New South Wales Administrative Decisions Tribunal.
I really think Australians are sick of being lectured to by the United Nations.
The US is right.
I'm not the UN, but I am going to lecture to you tonight about human rights. That was Tony Abbott's response to the UN's special raconteur on torture, recorded in the Sydney Morning Herald in March of this year, when the UN found that there was a violation of the rights of asylum seekers and the Convention Against Torture. What a cracker of a statement from the leader of a first world democratic nation in 2015. What I'm going to talk about tonight is why we need a Human Rights Act in Australia. Chris will run through some history of the debate in Australia and help explain why we don't already have one. I want us to identify some of the headline human rights issues that have peppered the debate. And as I do that, I want you to keep in mind this fact. Since Federation, successive Australian governments have justified the absence of a Human Rights Act or a Bill of Rights on the basis that we have in existence representative and responsible government, which would suffice to adequately protect the rights of people living in Australia. Representative and responsible government. What does that mean?
I mean, not anymore.
Word from the government, we're here to help. Trust us. Representative and responsible government will protect basic rights. We don't need a Human Rights Act. We don't need a Bill of Rights. We'll look after you. Well, let's just have a look at a few headlines over the last few years, last few months, last few weeks, and actually yesterday. In my view, the debate about rights, and which are fundamental, has been intensifying. Certainly most recently, barely a week goes by without a headline that evokes the narrative of rights. So let me touch on a few of them. This year, I think you probably know, is the 40th anniversary of the Race Discrimination Act. This legislation was overridden, was suspended during the Howard government's Northern Territory emergency response in 2007. You recall the package of legislation, the so-called reforms, attracted international condemnation. The UN found the legislation breached International Convention on Civil and Political Rights and the Convention on the Elimination of Race Discrimination. Do you recall Tony Abbott's response to the UN criticism back then? He was Indigenous Affairs Minister in opposition. Nonsense from armchair critics. Only last night, at a launch of a book about the intervention in Northern Territory, the President of the Human Rights Commission, Professor Gillian Triggs, described the intervention as a sad chapter in Australian history. Now recall this year in February, the Human Rights Commission came out with the Forgotten Children's Report. You'll recall this report was a report into the impact of immigration detention on children. The report found that the detention of children in immigration centres breached Australia's obligation under the Convention on the Rights of the Child, echoing that 2004 report you probably recall, A Last Resort, which similarly found that Australia's policy of mandatory detention breached numerous international immigration obligations. So the response in February of this year, 2005. Tony Abbott dismissed the report in February as a political stitch-up and the sometimes vicious campaign to demonise the President of the Human Rights Commission, Professor Gillian Triggs. Now, whether or not you think she's partisan, the government's repeated attacks on her and her position are unprecedented and have permanently weakened that position. Think also about the tough on crime agenda being implemented by most of state and territory governments around Australia, meaning that prison populations are on the rise. Prison capacity is not. Overcrowding in prisons leads to increasing violence, compromises inmates' physical and mental health. Research shows that access to medical care and welfare services for Australian prison population is certainly stretched. There's an extraordinary example that I have to share with you. The current situation in South Australia, the Department of Correctional Services currently requires all imprisoned people receiving medical treatment in hospital are to have their legs shackled together, including one arm and one leg to the hospital bed. And yes, this includes pregnant women and people receiving palliative care. Legislation in the last 2 weeks, the Border Force Act, that could see workers at both offshore and onshore immigration detention centres who speak out about the conditions at those centres. They could be jailed for 2 years. That legislation was passed with the support of both federal coalition and Labor governments. This prompted a group of doctors in Darwin this week to protest about what they call as the secrecy legislation. They saw that legislation as impacting upon their ethics and putting lives at risk. Now we've got the terror laws. Since 2014, there's about 50 or 60 separate pieces of legislation that have been passed dealing with anti-terror matters. Some of these pieces of legislation have been described as being incompatible with due process, standards of the presumption of innocence, and coupled with the far-reaching powers given to ASIO to detain and question even non-suspects. It seems that once an issue is described as a security issue, concerns about human rights are readily pushed aside. Now, again this week I think, or last week, metadata legislation. Have you heard this one? Mm-hmm. Authorities can now look at every website you visited in the last 2 years without getting any type of warrant. If anyone here torrents music or movies, be warned. There is no reason why a private company, such as a movie studio, could not be entitled to ask for permission to do the same. And lastly, gay marriage. What a debate. The issue of gay marriage is a highly divisive issue in the States. As you probably know, most US states did not allow gay marriage. You're all probably aware of the recent United States Supreme Court decision that found homosexual people have a constitutional right to marry. The constitutional rights in question were those of due process and equal protection before the law. In the US, these protections have been found to apply to fundamental rights central to individual dignity and autonomy. 5 of the 9 Supreme Court justices found that the right to marry is sufficiently fundamental to individuals to warrant constitutional protection. Having reached that decision, no Parliament, no Congress throughout the United States could say otherwise. So, Northern Territory intervention, children in immigration detention, asylum seekers, secrecy laws, the condition in prisons, terror laws, the metadata legislation and gay marriage. They are just a few examples of what I'm calling the headline debates about rights and how to protect them. I haven't even talked about women's rights, I haven't even touched on Indigenous rights, I haven't even talked about Indigenous kids in jail. But there's some headlines that I'm certainly aware of this week, last month, last year, and certainly in the last 5 years. But so what? We've got existing federal legislation, we've got existing state and territory legislations for discrimination laws, we've got the Human Rights Commission, we've got the courts. Surely that's enough. Why do we need another piece of legislation and more lawyers? Before I explain the whys, I'm probably speaking to people that know the difference, but I just want to explain the difference between a Bill of Rights and the Human Rights Act. You always hear about the US Bill of Rights. What that actually is 10 amendments that were made to the US Constitution at the time of the ratification of the Constitution in 1789. They form a part of their Constitution. They enumerate freedoms that were not explicitly indicated in the body of the Constitution. Freedom of speech, freedom of press, freedom of assembly, freedom to shoot each other up and kill each other. You know. Now in Australia, the favoured model is not this constitutional model. The favoured model is a statutory instrument, a statutory Human Rights Act, a piece of legislation, not amending the Constitution to insert a Bill of Rights or to insert a Human Rights Act. Because, and Chris will tell you all about this, constitutional Human Rights Act have been twice rejected in Australia in referendums. And as we know, changing the Constitution by referendum is near impossible. So when something's in the Constitution as well, the courts have the final say in its interpretation, and Parliament can't overrule the decision. The only way to change the law would be to either change the Constitution or have the court change its decision. Now just imagine if judges had to decide if the rights that were in the Constitution, if they applied, say for example, how the right to life and the right to autonomy applied to euthanasia or applied to abortion. I'm not sure they're things that you'd necessarily want to leave up to a judge. These are socially fraught issues and they should be dealt with by Parliament, by legislation. Forcing courts to try and resolve them is lazy and potentially undermining the judiciary. So the preferred model is for a piece of federal legislation. A Human Rights Act, and it's in the theme as what's been introduced in the ACT, Human Rights Act in Australian Capital Territory, and also a Charter of Human Rights and Responsibilities Act in Victoria. But why do we need a Human Rights Act if the government can just amend it when it wants? There's 3 main reasons. First, it will make it more difficult for any government to take away our rights and promote a culture of respect for human rights. 2, it will still have a huge legal influence on other laws. And thirdly, cred. It will bring Australia into line with the rest of the Western world and unify our current patchwork of rights. So let's unpack those 3 things. Making it more difficult for any government to take away our rights. Currently, Many of the human rights that Australians take for granted are not explicitly granted to us. There's no freedom of speech that's written anywhere. It's mentioned in some acts, it's implied in others, but there's no actual right to freedom of speech. Freedom of religion? No. Sure, the government would be hard-pressed to ban religion, but you have no right to stop the government restricting religious activities if it wants to. So a lot of the rights that we hold dear are only rights in the sense that the government hasn't passed legislation taking them away. By and large, generations of politicians have respected the powers entrusted to them. They have tried to act reasonably and not undermine conventions and institutions to obtain political objectives. We certainly don't have a perfect record. Aboriginal rights being one shameful example. But our culture of mutual respect and a fair go has granted Australians a degree of freedom and social stability that most countries have fought hard to obtain. And it is perhaps because of that past that we risk being complacent in the future. The greatest strength of our democracy can also be its greatest weakness. Reliance on mutual respect, reliance on goodwill, reliance on responsible and representative government. They'll look after us. They won't muck it up. Unfortunately, as I've indicated earlier, recent successive governments have shown an increasing willingness to push the limits of their power regardless of the criticisms they face. Northern Territory intervention, children immigration, mandatory, etc. It is dangerous indeed when a government becomes immune to political and international criticism. The United Nations equivocally stated that Australia's current asylum policy now breaches the Convention Against Torture. I really think that Australians are sick of being lectured to by the United Nations. That was the response. One of the most desirable outcomes of a Human Rights Act is that it makes it harder for any government to pass a law that violates human rights. Sure, they can overrule it. But that's the point. They'd have to actually stand up and say, yep, we're going to remove some of your rights. This is why, this is how we're going to do it, this is when we're going to do it. So it makes violation of the rights much clearer, much less palatable, and importantly, engenders accountability and open debate. Now that won't work every time, but all liberal democracies work on a system of checks and balances. A human rights regime provides a whole series of small measures that make it increasingly difficult for any arm of the government to overstep their powers. Will it be enough? No. But it sure as hell will help. And by forcing governments and bureaucrats to actually think about human rights implications of their actions, over time a culture of greater respect for their rights may develop. And there are signs of this actually happening, again in Victoria and in the ACT, where they have human rights legislation. There is a compliance with rights narrative that is emerging. Earlier in my speech I talked about how the Human Rights Act would not invalidate any other federal law. While that's true, it doesn't mean it wouldn't have any teeth. For one thing, many countries have allowed citizens to sue for various breaches of the rights contained in a Human Rights Act. Let's say, to use a hypothetical example, you get arrested by the Australian Federal Police because a friend of a friend of a friend used an old SIM card of yours soon before he committed an act of terrorism. Eventually, you're released without charge, only to be placed in immigration detention and deported from the country. You may think that that's a grossly disproportionate and unreasonable use of power.
But you don't have it dangerous.
You'd be right. I am, of course, talking about the case of Dr. Mohammed Hanif. Thankfully, his case was high profile enough. The government apologised, they backed down. But for all those cases that don't generate public attention, a Human Rights Act may well be the only way to seek some sort of compensation. And again, some commentators have used this to as an argument against a Human Rights Act, because there could be a flood of litigation. Well, in other countries that have passed a Human Rights Act, in the UK for example, litigation has increased by only about 2%. That's 2% of people suing for their rights. That's not a bad thing. So I talked about one of the first reasons why we needed a Human Rights Act. The second way is interpretation. The Human Rights Act can have legal force by its use to interpret other laws. Grey areas exist in law everywhere, let me assure you. Situations which don't quite fit within existing definitions. And you really can't be sure whether to interpret them one way or another. Currently, courts can only choose between very narrow interpretations. Despite the convincing arguments of Dennis Denuto in The Castle, the vibe is not an accepted legal test. A Human Rights Act would give courts the flexibility to interpret situations in a way that delivers the best outcome. The last reason, credibility, bringing Australia into line. Australia is unique amongst liberal democracies. It has no Human Rights Act. New Zealand, America, Canada and the UK all have a Human Rights Act in one form or another. Simply put, it is a source of international criticism and concern that undermines Australia's moral standing in the world. Now, in conclusion, if we had a Human Rights Act, what difference, if any, would there be to those headline human rights issues that I mentioned earlier? Northern Territory intervention probably wouldn't have stopped it. The government suspended the operation of the RDA, a very extreme measure. But a Human Rights Act would have caused the government to address fundamental human rights in its implementation of the so-called reforms. And it may well have left open the possibility of compensation. Legislation in respect of kids in detention, mandatory detention, the secrecy provisions, the metadata legislation may not have been passed at all, or at least again would have triggered the checks and balances requiring legislation to comply with human rights instruments. Instituting a Human Rights Act will not only bring Australia into line with its peers, but also unify the rights and protections that Australians are entitled to. Currently, our rights resemble a Jackson Pollock painting. We have some implied into the Constitution, we've got a few legal convention, we've got a haphazard sprinkling throughout legislation. Bringing these rights together into one act, even if it doesn't necessarily increase their force, will itself inform and protect Australian people. So, will Australia fall apart if we don't have a Human Rights Act? No, of course not. In all likelihood, we'll remain in a fairly free and respectful society well into the future. But a Human Rights Act increases that likelihood. It increases respect for human rights and makes it more difficult for those rights to be taken away. Everyone benefits from protecting the rights of a society as a whole. That is why Australia should adopt a Federal Human Rights Act. Thank you.